Good afternoon. Professor McLaughlin here. It's that time of the week where we post our weekly lecture, and today we're going to talk about chapters 10, 11, and 14. We'll get into the formation of a contract and some of the things that are necessary when you have a contract to make it valid and all sorts of interesting stuff like that. What I'm going to do is I'm going to give you kind of an overview and then make sure you follow up by reading the cases that are applicable to each of these sections. You'll see each section in your textbook, and then there's some great cases that go over the law and how the court arrived at their decision. But what I want to do right now is I just want to kind of give you a 10,000 foot view of, contracts, the UCC, and great stuff like that. So moving right along, let's talk about Chapter 10, which deals with formatting a contract or creating a contract. And here's the theme for the chapter. A valid offer creates a power in the offeree to create a contract by agreeing to its terms. Contracts make business matters more predictable and are integral to the day-to-day business and personal life. Understanding how contracts are formed, the rules of contract law, the remedies the law has created to address harm that can result when formal contract rules don't apply enables a greater control over one's life. And as always, I like to kind of start out with some quotes of the day. And this one comes from Lord Melbourne in the late 1700s. He was a British Prime Minister. And what he said, the whole duty of government is to prevent crime and to preserve contracts. And then you have Henry David Thoreau, which I'm sure many of you are aware of. He made this comment or this statement. It takes two to speak the truth, one to speak and another to hear. Kind of interesting quote. Let's talk about how we approach contract law. And we see every day people make promises. They make promises every day. The law will enforce some, but not others. You may ask why. What distinguishes a promise the law will enforce, a contract, from a promise the law will not enforce? One way for students to begin to understand the differences between unenforceable promises and contracts is to pose common examples of the former and ask why the law would not enforce them. For example, suppose one student asks another out on a date, say to attend a party on the coming Saturday night. The invited student makes preparations for the date. They go and buy clothes, purchase clothes, they get their hair done, or if they're a guy, they get a haircut, whatever fits the situation. The student who issued the invitation doesn't show up at the appointed time. The question is, can the student who stood up sue the other for breach of contract? Experience tells students the answer is, of course not. But why is that so? The promise involves an offer, an acceptance. Would you like to go to this party with me on a Saturday night? I'll meet you at your apartment at, say, 10:30. Sure, that would be great. You have consideration. Each party promises to do something he or she is not otherwise obligated to do, and each gives his or her promise in exchange for the other promise. Why can't the disappointed student file a breach of contract lawsuit as soon as the courts open on Monday? Certainly one reason the law would not enforce this promise is that while there is an offer and acceptance, there was no intent to form a contract. These parties thought they were agreeing to go out on a date, which does not create contractual expectations. Despite the emotional expectations that may arise. However, if one person changes the facts somewhat, a businesswoman, an out-of-town conference arranges for a male escort from a legitimate companionship service to attend a business/social engagement, then fails to show up at the appointed time, the party's expectations take on the aspect of a contract. One purpose of contract law, then, is to distinguish unenforceable day-to-day promises from legally enforceable promises. Very important. Let's talk about the elements of a contract. Well, a contract is a legally enforceable agreement. For a contract to be enforceable, 7 key characteristics must be present. And this is more of a grocery list, but you might want to write this down. First of all, you have to have a valid offer. Okay, no offer, no contract. Then you need to have a valid acceptance. Then there has to be consideration, that which is being bargained for in the offer and acceptance. The fourth thing is it has to be legal. You can't make a contract if it deals in committing crimes or illegal goods. The next thing is capacity. You have to have the capacity. You cannot be a minor and form a valid contract. Then you need consent. There has to be consent to the contract. And then usually, but not all the time, as we'll find out, it has to be in writing. And while verbal agreements are often contracts, make no mistake about that, but there are verbal contracts, some types of contracts must be in writing to be enforceable. Let's go back a little bit in history and talk about the development of contract law. Courts have not always assumed that promises are legally significant. Going back to British common law in the 12th and 13th centuries, promises were not binding unless a person made them in writing and affixed a seal. Seals were very big in those days. If there was no seal, the document most probably wasn't valid. This was seldom done, and therefore most promises were unenforceable. Some of the other issues we'll talk about are third-party issues, performance of a contract and discharge of a contract, and remedies. Let's talk a little bit more. Let's narrow it down, or narrow the focus down to contracts defined. Is it certain that the defendant promised to do something? That's one question you have to ask. A second question is, if she did promise, is it fair to make her honor her word? And the third is, if she did not promise, are there unusual reasons to hold her liable anyway? Let's talk a little bit about the types of contracts. The first contract we're going to talk about is a bilateral contract where both parties make a promise. When the bargain is a promise for a promise, it is a bilateral agreement. In a unilateral contract, only one party makes a promise that the other party can accept only by actually doing something. A contract is executory when it has been made, but one or more parties has not yet fulfilled its obligations. The moment the parties strike a bargain, they have an executory bilateral express contract. A contract is executed when all parties have fulfilled their obligations. Also, a valid contract is one that satisfies all of the law's requirements. It has no problem in any of the 7 areas that we just listed previously at the beginning of this chapter, and a court will enforce it. An unenforceable agreement occurs when the parties intend to form a valid bargain, but a court declares that some rule of law prevents it from enforcing it. Then you have something that's a little bit different, and it's called avoidable contract. And that occurs when the law permits one party to terminate the agreement. This happens, for example, when the other party has committed, say, fraud, or when an agreement has been signed, say, under duress or by force. A void agreement is one that neither party can enforce, usually because the purpose of the deal is illegal. So then we're back to the illegal aspects of a contract or a deal. And it's illegal because one of the parties had no legal authority to make that particular contract. Then we have what we call express and implied contracts. In an express contract, the two parties explicitly state all important terms of their agreement. The vast majority of contracts are express contracts. Some express contracts are oral, and some are written. Remember, we said at the beginning of the chapter, verbal contracts are enforceable. In an implied contract, the words and conduct of the parties indicate that they intended an agreement. Okay? Students often find implied contracts very difficult to understand, so make sure you go over that section 2 or 3 times so you understand it. And they find it difficult to understand perhaps because the other paired terms introduced in this section present two faces of some aspect of the contract: bilateral and unilateral, executory and executed. People don't enter negotiations with with the intent to form an implied contract. Implied contract is not another method of forming a contract, but a remedy a court may apply after the fact if there was no valid contract between the parties, but their words and conduct manifest implied intent that certain promises would be legally enforceable. The next area we're going to move into is promissory estoppel and quasi-contract, and you should know the difference between these two. And again, feel free to go back in the chapter and look at some of the cases that are examples of a lot of these types of contracts, and in particular, promissory estoppel and quasi-contract. It's important that you know and understand the differences. And with promissory estoppel, even when there is no contract, a plaintiff may use this theory to enforce the defendant's promise if he can show the following three things. Number one, the defendant made a promise knowing that the plaintiff would most likely rely on it. Let me say that again. The defendant made a promise knowing that the plaintiff would likely rely on it. Number two, the plaintiff did indeed rely on the promise. And number three, the only way to avoid any type of injustice is to enforce this promise. Under quasi-contract, again, even when there is no contract, a court may use quasi-contract to compensate a plaintiff who can show that, or show one of the following three things. One, the plaintiff gave some benefit to the defendant, okay? The defendant received a benefit. Number two, the plaintiff reasonably expected to be paid for the benefit, and the defendant knew this. And number three, the defendant would be unjustly enriched if he did not pay. So we talked about promissory estoppel and we talked about quasi-contract. Let's go back a little bit and look at the sources of contract law. Under the common law, express and implied contracts, promissory estoppel, and quasi-contract were all crafted over centuries by appellate courts deciding one contract lawsuit at a time. Many contract lawsuits continue to be decided using these common law principles developed by courts. Another source is the Uniform Commercial Code. And in law school, we basically had one whole class on the Uniform Commercial Code. And the UCC, as I'll refer to it in the future, was created in 1952. The drafters intended the UCC to facilitate the easy information and enforcement of contracts in a fast-paced world. The code governs many aspects of commerce, including the sale and leasing of goods, negotiable instruments, bank deposits, letters of credit, investment securities, secure transactions, and other commercial matters. Every state has adopted at least part of the UCC to govern commercial transactions within that state. For our purposes, in studying contracts, the most important part of Code 2 is Article 2, which governs the sale of goods. And let's define goods. Goods means anything movable except for money, securities, and certain legal rights. And the UCC governs contracts for the sale of goods, while common law principles govern contracts for sales of services and everything else. Most of the time it'll be clear whether the UCC or the common law applies, but what if a contract involves both goods and services? In a mixed contract, Article 2 governs only if the primary purpose was the sale of goods. So in your mind, keep it that, as a general rule, the UCC applies to the sale of goods. You might ask, when you're forming a contract, how do you know when you have an agreement? Well, an agreement in essence is a meeting of the minds. For a meeting of minds to happen between parties, one side must make an offer and the other side has to make an acceptance. The person who makes the offer is called the offeror. The person to whom he makes that offer is the offeree. Two questions determine whether a statement is an offer. Number one, do the offeror's words and actions indicate an intention to make a bargain? And number two, are the terms of the offer reasonably definite? They can't be ambiguous or indefinite. An invitation, let me repeat this, an invitation to bargain is not an offer. If somebody invites you to start a bargaining process, That does not constitute an offer. The terms of the offer must also be definite. How do you terminate an offer? Let's say you've got an offer out there and you want to terminate it. Well, offers may be terminated by revocation, rejection, expiration, or by operation of law. An offer is revoked when the offeror basically takes it back before the offeree accepts. In general, the offeror may revoke the offer any time before it has been accepted. So that's a revocation. What's a rejection? A rejection may be clearly stated and immediately terminates the offer. How about a counteroffer? A party makes a counteroffer when it responds to an offer with a new and different proposal. Okay, let me restate that. A party makes a counteroffer when it responds to an offer with a new and different proposal. And a counteroffer by itself constitutes a rejection. A counteroffer is a rejection. How about expiration? When an offer specifies a time limit for acceptance, that period is binding. So if a person gives another person 1 week, they have to respond within a week. If not, the offer expires. If the offer specifies no time limit, the offeree has a reasonable period in which to accept. How about when the item you're negotiating over, let's say it's an automobile, gets destroyed, or the subject matter or the consideration in the contract is destroyed? When the subject matter is destroyed, the offer is immediately terminated. What constitutes an acceptance? The offeree must say or even do something, an act, to accept. And under UCC 2207, dramatically modifies the mirror image rule for the sale of goods. Under this provision, an acceptance that adds additional or different terms will often create a contract. The rule is intricate, but it may be summarized this way. For the sale of goods, the most important factor is whether the parties believe they have a binding agreement. If their conduct indicates that they have a deal, they probably do. If the offeree adds new terms to the offer, acceptance by the offeror generally creates a binding agreement. But if the offeree changes the terms of the offer, a court will probably rely on general principles of the UCC to create a fair contract. If a party wants a contract on its terms only with no changes, it must clearly indicate that. How do we communicate the acceptance? Well, the offeree must communicate his acceptance for it to be effective. The questions that typically arise, and what you will see in the cases in the textbook, concern the method, the manner, and the time of the acceptance. Let's talk about the method and manner of acceptance. The method refers to whether acceptance is done in person or by mail, telephone, email, or even a fax. You don't hear much about faxes anymore. The manner refers to whether the offeree accepts by promising, by making a down payment, by performing, and so forth. If an offer demands acceptance in a particular method or manner, the offeree must follow those requirements. If the offer does not specify a type of acceptance, the offeree may accept in any reasonable manner and method. And the rule that's used generally in regard to the time of acceptance is what we call the mailbox rule. And this dates back to when the only way to communicate was by mail. No telephones, no fax machines, no texting. And so the mailbox rule is an old rule, but it's still important. It's still enforced today. And the rule states this: an acceptance is generally effective upon dispatch, which means when it's sent, meaning the moment it is out of the offeree's control, boom. Let me say that again. An acceptance is generally effective upon dispatch, meaning the moment it is out of the offeree's control. Terminations, on the other hand, are effective when received. And I would say today that most offers and acceptances are made pretty much by email. Sometimes, you'll have a party who demands a hard copy, but pretty much that's the way it's done today. So that kind of gives you an overview of Chapter 10. Let's move on to Chapter 11, which are the requirements for a contract. And as we said before, let's start with a brief overview of the chapter. As we said before, the law does not hold us accountable for every promise we make. The doctrine of consideration determines which promises a court must enforce. Bargaining a contract with a non-complete or exculpatory clause that is too one-sided may lead a court to ignore it. Both parties must be adults of sound mind and must give genuine consent. Let me repeat that. Both parties must be adults of sound mind and must give genuine consent. No matter how profitable a particular contract clause may appear to be, it is worthless if it's illegal. And as I do on most chapters, let me give you the quote of the day. This comes from none other than George Washington, our esteemed first president. And George Washington said, "Gambling is the child of avarice, the brother of iniquity, and the father of mischief." And then a quote I even like better is by Samuel Goldwyn, the famous Hollywood producer. And here's what he had to say about contracts. "A verbal contract isn't worth the paper it's written on." Kind of catchy, huh? So let's talk about consideration, which is that which is bargained for in the contract. There are two basic elements of consideration. One, both parties must get something of measurable value from the contract. The key word here is measurable. Number two, the two parties must have bargained for what is ever exchanged and struck a deal. In other words, hey, if you do this, I'll do that. What constitutes value in an agreement or in a contract? Well, as we've seen, an essential part of consideration is that both parties must get something of value. That item of value can either be an act, doing something not required by law, or what we call a forbearance. A forbearance. And that's an agreement to not do something that is otherwise allowed by law. Or a promise to act or forbear, a promise to do or not to do something in the future. So we've talked about consideration. There has to be value. What constitutes an exchange? The parties must bargain for the consideration. Something is bargained for if it is sought by the promisor and given to the promisee in exchange for their respective promises. Courts do not analyze the economic terms of an exchange to determine whether consideration was adequate. For consideration to be adequate in the eyes of the law, it must provide some benefit to the promisor or some detriment to the promisee. But these need not amount to much. Law professors often call this the peppercorn rule, a reference to a Civil War era case in which a judge mused, what is a valuable consideration? Something as tiny as a peppercorn? The next thing we'll discuss is the legality. In this section, we examine a type of clause common in employment contracts. And it will probably be the one you see the most throughout your career, particularly if you arise to senior levels of management, and it's the famous non-compete agreement. Again, this is something you will deal with, particularly if you've had a key position in a company and you go to another company or you arrange some sort of severance package. A lot of times, if they pay you money or consideration, they'll have you sign what they call a non-compete agreement or non-compete. A non-compete agreement is a contract in which one party agrees not to compete with another in a stated type of business. And usually we see this when somebody sells their company, and particularly if it's a technology company or a company that's got a fairly large database. They don't want that former owner that has just sold his company going out and starting a new business. So they'll make them sign a non-compete. But for that non-compete to be valid, that former owner has to receive something in consideration, and usually it's cash and stock. To be valid, an agreement not to compete must be ancillary to a legitimate bargain. Ancillary means that the non-competition agreement must be part of a larger agreement. And as I just described, that usually occurs in the sale of a company. The two most common settings for legitimate non-competition agreements are the sale of a business, which I just talked about, and an employment relationship. And again, under the non-compete, you can't go out and start another business. Also, you can't go to work for somebody else. A lot of times, if you sell your company and your company's been, fairly successful, they're going to tie you down pretty tight, particularly if they've paid you a considerable amount of money. What are exculpatory clauses? We've got 4 definitions, basically, or 4 parts of the definition. And an exculpatory clause is generally unenforceable when it attempts to exclude an intentional tort or gross negligence. An exculpatory clause is usually unenforceable when the affected activity is in the public interest, such as medical care, public transportation, or some essential service. An exculpatory clause is generally unenforceable when the parties have greatly unequal bargaining power, which means the balancing has done this. One is in a far superior position to the other. And we talked earlier about having the capacity. And capacity is the legal ability of a party to enter into a contract. Someone may lack capacity because of his young age, or maybe he's got some mental infirmity, one of those things, but he's incapable of making a prudent judgment. 2 groups of people usually lack legal capacity. The first one we already talked about, minors, and those with a mental impairment. A lot of times you'll see this issue pop up when somebody becomes elderly and they do something fairly severe, and if it can be proved in court that they weren't in their right mind, then it can be set aside and say they weren't capable of making the decision. You run into this a lot, particularly with patients who develop Alzheimer's. And for purposes of the law, a minor is someone under the age of 18. And because a minor lacks legal capacity, she normally can create only a voidable contract. A voidable contract may be canceled by the party who lacks capacity. Notice that only the party lacking capacity may cancel the agreement. A minor who wishes to escape from a contract generally may disaffirm it. That is, he may notify the other party that he refuses to be bound by the agreement. A minor who disaffirms a contract must return the consideration, i.e. money, automobile product he has received, to the extent that he is able. And then in regard to folks that are mentally impaired, a person suffers from a mental impairment if by reason of mental illness or defect he is unable to understand the nature and the consequences of his action. And a party suffering mental impairment usually creates only a voidable contract. The law creates an exception, though. If a person has been adjudicated insane, then all of the future agreements are void. Let me say that again. If a person has been adjudicated, or in other words, legally declared insane, then all of his future agreements are void. What's some of the reality of consent? Well, let's talk about fraud. We've talked about fraud a little bit before in some of the previous chapters. The distinction between misrepresentation and fraud lies in intent. Okay? Misrepresentation can occur incorrectly without awareness of the statement's falsity. If the defendant knows a statement of fact is false or is uncertain whether it is true and intends that the other party rely on that statement, then there is fraud. To recover from fraud, the injured person must show the following. 1, the defendant knew that his statement was false, or that he made the statement recklessly and without knowledge of whether it was false. Next, the false statement was material. And third, the injured party justifiably relied on the statement. So let's say fraud has occurred. What are some of the remedies? Well, here are the plaintiff's remedies. In case of fraud, the injured party generally has a choice of rescinding the contract or suing for damages, or, in some cases, doing both. Incorrect misrepresentation. If all elements of fraud are present, except for the misrepresentation of fact, was not made intentionally or recklessly, then the innocent misrepresentation has occurred. So if a person mistakes a material fact and induces reliance, but he had good reason to believe that his statement was true, then he has not committed fraud. Most states allow the rescission of a contract, but not damages in such a case. And again, I'd look at the cases in the textbook as examples. Under the theory of mistake, not all mistakes are created equal. Some mistakes lead to voidable contracts. Others create enforceable, if unfortunate, deals. So how can we know the difference? Well, first, we must ask who was mistaken, because different rules apply to unilateral and mutual mistakes. We must also examine the character of the mistake to see if circumstances warrant a rescission. Let's talk about a unilateral mistake. Sometimes one party enters a contract under a mistaken assumption. The other is not mistaken. In these cases, it is not very easy for the mistaken party to rescind the contract. How about when there's a mutual mistake? A mutual mistake occurs when both contracting parties share the same mistake. If the contract is based on a fundamental factual error by both parties, the contract is voidable by either one. Let's talk about the statute of frauds. This is in regard to contracts in writing. And under the statute of frauds, a plaintiff may not enforce any of the following agreements unless the agreement or some memorandum of it is in writing and signed by the defendant. The agreements that must be in writing are the following. Number one, for any interest in land, real property, real estate, any interest in land. Number two, for a contract that cannot be performed within 1 year, 365 days. To pay the debt of another, a promise or an agreement made by an executor of an estate, or a promise or a contract made in consideration of marriage. And then finally, for the sale of goods worth $500 or more. $500 is the threshold. It has to be over $500. So what's the purpose of the statute of frauds? Well, here's the answer. The purpose of the statute is to provide a court with the best possible evidence of whether the parties intended to make a contract. You might ask, why has the statute of frauds historically included 6 types of contracts listed above? And the answer is the statute of frauds dates all the way back to the year 1677. Historically, these 6 agreements were the most important. The British Parliament was attempting to avoid fraud in the most valuable business deals. And let's ask ourselves, what is the effect of the statute of frauds? It makes an oral agreement, and the answer is it makes an oral agreement to which it applies unenforceable. Is unenforceable the same as void? No. Unenforceable means that if one party fails to perform a promise to the other fails to perform its promise, the other party will not be able to enforce their agreement in court. And then the next question you might want to ask is, what is the difference between an unenforceable contract and a void contract? And the answer is the difference is that if the parties do perform the contract, it makes no difference that it was oral. Okay? If the seller delivers the deed to the property and the buyer pays for it, the sale is fully executed and neither party may rescind it. Final question, is it still true today that the most valuable contracts must be in writing? And the answer, as I said at the beginning of the lecture, is no, not necessarily. For example, employment contracts need not be in writing unless they could not be performed within 1 year, i.e. 365 days. What are the types of contracts that have to be in writing? Well, first of all, agreements in the interest of land. A contract for the sale of any interest in land must be in writing to be enforceable. Notice the phrase I use, interest in land. This means any legal right regarding land, including easements, mortgages, and the sale of real property. Are there some exceptions? Always. In the law, we always find exceptions. One exception is if you have full performance by the seller. Number 2, if you have part performance by the buyer. Or number 3, if it's enforceable under promissory estoppel. How about agreements that cannot be performed within 1 year? And contracts that cannot be performed within 1 year are unenforceable unless they are in writing. What about other contracts that must be in writing? How about a promise to pay the debt of another? Or a promise made by an executor of an estate? Or a promise made in consideration of marriage? Those all have to be in writing. If we know it has to be in writing, what must the writing contain? Well, the writing may consist of more than one document. It can be written at different times, and with each making a piece of the puzzle. So you can have multiple pieces to this contract or this puzzle, but there are some general requirements. The writing, number one, must be signed by the defendant, and number two, it must state with reasonable certainty the name of each party, the subject matter of the agreement, and all of the essential terms and promises. So we live in a digital age now where everything's done electronically. No more analog, all digital. What about electronic contracts and signatures? What happens to the writing requirement when there is no paper? Well, the statute of frauds requires some sort of signature. Today, we have electronic signatures, which you see all the time. When you agree to accept an update on your Apple software, you have to sign the agreement. Sometimes you have to create an electronic signature. And usually that means a typed or automatically included signature that's at the bottom of an email message, a retinal or vocal scan, or a name signed by electronic pen on a writing tablet, among others. E-signatures are valid in all 50 states. Okay, an e-signature is good in any state. Almost all states have adopted the Uniform Electronic Transaction Acts, or the UETA, which declares that electronic contracts and signatures are as enforceable as those on paper. In other words, the normal rules of contract law apply, and neither party can avoid such a deal merely because it originated in cyberspace. Okay? A federal statute, the Electronic Signatures in Global and National Commerce Act, or the e-sign, excuse me, extends UETA's principles to interstate and foreign commerce as well. In many states, certain documents will require a traditional non-electronic signature. Documents like wills, adoptions, court orders, and notice of foreclosure are common exceptions. Okay? Let's go back to the sale of goods. UCC requires a writing for the sale of goods priced at $500 or more. This is the sixth and final contract that must be written, although the code's requirements are easier to meet than those of the common law. In some cases, the UCC dispenses altogether with the writing agreement. The basic statute of frauds rule is section 2201. And you can also see other important exceptions that are found in 22012 and 22013. So we've kind of moved through chapter 11. We know about a contract. We know about what makes it enforceable. So let's go to the final chapter we're going to be dealing with here, and that's the section on sales. And that impacts probably everybody more today than in the past, or I should say most of you sitting out there, because we do purchases and sales almost every day, whether they're electronically online, we go buy gas, buy something in the store. So let's talk a little bit about sales, and then that'll wrap up this particular session. The chapter theme in sales is the Uniform Commercial Code enables merchants to form contracts quickly and easily, but along with this increased facility goes greater responsibility, as informal discussions may suddenly turn into a contract. Does that happen in business? All the time. You can be in an informal discussion, and at the end of the discussion, you're in a full-blown contract. Let's go back to our quote of the day. Now, I have to apologize because I'm quoting Karl Marx, the father of communism, but this is a pretty good quote. What he said was, a commodity appears at first sight an extremely obvious, trivial thing, but its analysis brings out that it is a very strange thing, abounding in metaphysical subtleties and theological niceties. That kind of sounds like a philosopher, doesn't it? It also sounds a little bit like double talk, but that's the quote for this particular chapter. Moving along on the development of the UCC, by the mid-20th century, two problems had become apparent here in the United States. One was old contract law principles often did not reflect modern business practices. And we talked about that earlier, even going back to the seals that were used and implemented in the 16th century. And also laws had become different from one state to another. So at the time, this goes back quite a ways, you had, when there were only 48 states, you had 48 different interpretations of the law. The UCC was created as an attempt to solve these two problems. It was basically a proposal written by legal scholars and not a law drafted by members of Congress, okay? The UCC did not come from Congress, and it did not come from a state legislature. In this particular chapter, they talk about sales of goods. And a good is any movable physical object except for money and security, like stock certificates. A home, a house, is not a good. But the things inside the house, the car in the garage, the televisions, the furniture, and the paintings hanging on the wall, those all are. Article 2 applies to contracts that sell goods and also to contracts that sell a mix of goods and services if the predominant purpose of the deal is to sell goods. Under the UCC, this applies also to merchants. So let's define what a merchant is. The UCC evolved to provide merchants with rules that would meet their unique business needs. However, while the UCC offers a contract law that is more flexible than the common law, it also requires a higher level of responsibility from the merchants it serves. Under 2104 of the UCC, a merchant is someone who routinely deals in the particular goods involved or who appears to have special knowledge or skill in those particular goods or who uses agents with special knowledge or skills in those goods. And the UCC frequently holds a merchant to a higher standard of conduct than a non-merchant. Let's talk about contract formation, the basics. Under UCC 2204, it provides 3 important rules that enable parties to make a contract quickly and informally. The first is the parties may make a contract in any manner sufficient to show that they reached an agreement. Number 2, the UCC will enforce a deal even though it is difficult in common law terms to say exactly when it was formed. And number 3, under the UCC, a court may enforce a bargain even though one or more terms were left open. The UCC also embraces the statute of frauds, and under UCC 2201, it requires a writing for any sale of goods worth $500 or more. We've already kind of beat that to death. However, under the UCC, the writing need not completely summarize the agreement, and it need not even be entirely accurate. How about that? If it isn't confusing enough, it need not even be entirely accurate. The code only requires a writing sufficient to indicate that the parties made a contract. In other words, the writing need not be a contract, but one term is essential under the UCC. One term is essential to a contract, and that is quantity. The code will enforce the contract only up to the quantity of goods stating in writing. Are there exceptions? We've talked about this so far the whole semester. Of course there is. In law, there's always exceptions. And here we have the merchant exception. This is a major change from the common law. When 2 merchants make an oral contract and one sends a confirming memo to the other within a reasonable time, and the memo is sufficiently definite that it could be enforced against the sender herself, then the memo is also valid against the merchant who receives it unless he objects within 10 days. So it can be enforced against the sender herself, then the memo is also valid against the merchant who receives it unless he objects to it within 10 days. How about if you add on some additional terms? Hey, I want it delivered to my warehouse in Riverside as opposed to the one that's up in Glendale. Under 2207, that deals with what we call the battle of forms that can arise when a buyer places an order using its pre-printed form and the seller acknowledges it with its own pre-printed form. Each party's form contains self-serving language, so the 2 forms rarely agree. Section 2207 establishes the legal consequences of such conflicting forms. Let's talk a little bit about the performance and remedies. Okay, first we'll start with the buyer. What are the buyer's remedies? A buyer has a right to inspect the goods before paying or accepting and may reject non-conforming goods by notifying the seller within a reasonable period of time. You can't do it a year later. It has to be a reasonable period of time. If the seller breaches, the buyer may cover by reasonably obtaining substitute goods. It may then obtain the difference between the contract price and its cover price, plus incidental and consequential damages, minus expenses saved. An injured buyer is generally entitled to incidental and consequential damages. How about the seller's remedies? If the buyer breaches, the seller may refuse to deliver the goods. If a buyer unjustly refuses to accept or pay for the goods, the injured seller may resell them. If the resale is commercially reasonable, the seller may recover the difference between the resale price and the contract price plus incidental damages minus expenses saved. Finally, the seller may simply sue for the contract price if the buyer has accepted the goods, or if the goods are conforming and a resale is impossible. And then finally, we talk about warranties. A warranty is a promise that goods will meet certain standards. If you buy a pair of shoes, you have to make sure that the soles are attached, there's no holes in the shoes, there's some way to secure the shoes, i.e. laces. So it has to meet certain standards. Normally, a manufacturer or a seller gives a warranty and a buyer relies on it. And a warranty can be either explicit or written. An express warranty is one that the seller creates with his words or actions. And then in addition to express warranties, we have implied warranties. And under implied warranties, probably the most important is the implied warranty of merchantability. Merchantability is a concept non-lawyers are not familiar with. It means that goods are fit for a particular purpose or for their normal purposes. So that's implied warranties. So I've kind of given you a brief 10,000 foot view of what we're covering this week. Obviously, there's a lot of other things in there, but I at least wanted to get something out to you to kind of review in these chapters. And again, check with the cases. There's some great examples in there. We don't have time, in one lecture to go over all the cases from 3 different chapters, but make sure you do it. The other thing is make sure you're working on your projects and that you're keeping up with that. So far, most of the work I've seen is very, very good. You guys are doing a really great job. Again, some of the issues I'm running into are with sentence structure, grammar, and articulation. That's something you really, really have to work on to be successful and to kind of arrive at the pinnacle of the business pyramid. So keep working on that. I'll look forward to getting your thoughts and papers this week, and have a blessed week. Of course, if you have any questions, feel free to email me. Take care and God bless.